At worst, the law simply hasn't changed for court reporters after AB5. At best, there is at least one exemption, the business-to-business exemption, which I think and I hope a very large number of reporting firms would be able to avail themselves of. My name is Ed Howard from Sacramento, California, president of Howard Advocacy, Inc.
But today's a little bit different. Today's more of a special edition because I know you don't have a lot of time. We're here at the Deposition Court Association Fall Conference, and we are in Riverside, California. Beautiful. So I would guess that my next guest is likely one of the top 3 smartest humans I've ever met in my life.
You need to get out more.
And I haven't met the other 2 yet. So his intelligence, verbal acuity, humility, and profound charm make him a powerful attorney and lobbyist for many industries, but specifically the court reporting industry. Senior counsel for the Children's Advocacy Institute and the Center for Public Interest Law based out of University of San Diego School of Law. He's also president of Howard Advocacy in Sacramento. He even has his very own Wikipedia page because his life is arguably encyclopedic. So, Ed Howard, I basically just have one question for you. How are you doing?
If that's the one question, that's a pretty easy one. I'm doing fine. Thank you. It's good to see you, Tom.
Good morning. Good morning. Morning. So I know we are on a time crunch. You're on a, you're not here to do this, but I just threw these mics at you.
Sure.
So I posed all of my questions regarding AB5 in sort of a true-false, rapid-fire way.
Okay.
Then you can choose to expand and clarify any of them as you so wish.
Okay, that'll be fun.
Okay, cool. Perfect. Okay, true or false? The field of court reporting is doomed.
False.
True or false? Prior to April of 2018, including when I successfully passed my EDD audit in 2014, 2015, it was the Borrello test that was used to determine whether or not a worker was an IC, independent contractor, or employee.
Correct. True.
True or false? In around April of 2018, the Dynamics case introduced a new test called the ABC test.
True.
True or false? The ABC test has been the law for wage and enforcement since April of 18. It's not created by AB5. It's codified and clarified by AB5. True or false?
Yeah, mostly true.
Mostly. True or false? While attempting to correct certain ills around the workspace, AB5 has introduced some unintentionally harmful consequences to industries such as ours.
I would say false.
False. Why is that false?
It's false because at worst, the law simply hasn't changed for court reporters after AB5. At best, there is at least one exemption, the business-to-business exemption, which I think and I hope a very large number of reporting firms would be able to avail themselves of. So at worst, nothing changed for you because all it simply did was codify what was already the law. But
which we're successfully doing business under.
Well, or not.
Or not. But you were.
Right. So the ABC test, the Dynamics test, was the test prior to AB5. It remains the test after AB5. And but there is an exemption which hopefully a lot of your listeners will be able to avail themselves of in AB5.
Perfect. If I don't address any of that in my little true or false thing here, then you jump on that.
Absolutely.
Okay. It's likely in the ABC test, the points A and C are fairly easy to pass, but the B point has always been, if you're going to fail, it's likely that's the most problematic one that you're going to fail on.
Absolutely true.
True or false? A court reporting agency characterizing what they do as matching service and not in the business of court reporting, that is a helpful characterization. True or false?
Maybe, depending upon AB5 and what pathway you decide to take under AB5.
Okay.
There's an exemption which potentially applies if you're able to change the characterization of your business. So, provisional, yes.
Good. True or false? AB doesn't require full-time employment for employees. Someone could work literally 1 hour as an employee or 70 hours a week. It does require that minimum wage and overtime such are paid.
True. And the only reason why you heard me sort of say true at the end of it was because there is a difference between what the law technically says and between the risk that someone would actually sue you to enforce the law. So yes, that is technically true. The likelihood of being sued and being hurt by someone who worked an hour for you is very low.
True or false? AB5 doesn't require, Lorena Gonzalez said in a tweet that there are ongoing talks between some industries to add additional clarifying language right now. So true or false, is there still a possibility to add clarifying language for the court reporting industry 19?
Yes, we took a run at it this year. We're obviously not successful. We're planning on taking another run at it next.
If we had a magic wand, what would we want the court reporting exemption language to state?
It would simply reference the B&P codes under which court reporters are licensed and add it to one of the existing lists, probably the one that already exists for lawyers.
The true or false, most professional, including us court reporters, were not expressly exempted by the bill, notwithstanding DRA's efforts to obtain such an exemption. True or false, DRA will resume lobbying efforts for an exemption come 2020.
True.
True or false, our goal is to get court reporters to be under the Borrello test, not the ABC test.
True.
Because we want the Borrello test.
Right. Now, I want to, yes, because all that would happen if you were exempt is you would default to the Borrello test. Now, I do want to say one thing, and that is that the Borrello test was not a toothless test. And in fact, some of my dearest firm owners, I think if they were actually scrubbed next to the Borrello test, probably wouldn't have passed it. So I think that what all of the brouhaha and ha about dynamics has created is a situation where everybody has to take a hard look at what their independent contracting policies were and practices were to make sure that even under the old law, even the law that you successfully, beat back, that you were compliant.
Good. You shared with me your handout that you're going to be talking about today here at the Deposition Reporters Conference. True or false, from your handout, page 2.
Yeah, you may have, let me see, you have an older one.
Yeah. Slightly older one?
Mm-hmm.
Let me just ask the question, because it's about that catch-all. So did that change?
That did not change.
Okay, catch-all number 1, in a nutshell, is, to my understanding, 1 is that the ABC test must be satisfied. 2, the profession must appear in the list of not employees in the unemployment insurance code, which we do in that code, IUC 630. And then 3, if all of that is in place, then the worker is not an employee. Is that a nutshell, correct? Or not?
The shell of the nuts a little broken. The easiest way to describe
the catch-all number 1.
The premise of it starts off with what you had asked earlier. This really only works if you're able to characterize your business as sort of a matchmaking business. Mm-hmm. So it's a practical matter. If you decide that that's the avenue you want to go down to try and exempt yourself, then this would only as a practical matter apply to that strategy. And then the rest of what's here
meaning the catch-all.
In the catch-all, and what we're talking about, just for your listeners, is Labor Code 2750.3. What we're really looking at here are simply boilerplate things that would apply under any kind of independent contractor test. So the most important piece of this statute when it comes to trying to find an exemption is the person, would be A1, capital B. The person performs work that is, quote, outside the usual course of the hiring entity's business. Mm-hmm. So if your business is referrals and you're hiring a reporter, that's outside of your business model because your business model is referrals. So the rest of this is just, you are customarily involved in a trade. Yes. Are you free from control?
Would it help the case for, hey, we're a matchmaking service, if we also offered other services that were not court reporters? Let's say we got into the modeling agency, or we sent photographers, or we sent, extras on movie sets. Would that in our basket of services that we offered, hey, we're just matchmaking for all these areas?
That would absolutely matter. I mean, the more that it is genuinely true that you're
true. Yeah. Not some fart.
The less likely it is that
the webpage says we do.
Right.
Well, show us an invoice for the last model you sent out.
That's exactly right.
Okay.
So it's probably useful to skip ahead there to, in the handout that will be available here. One of the things that I suggest if you're going to go down this particular pathway and seeking an exemption is in your independent contracting arrangements with your reporters, that you memorialize that, in fact, this is your business model. So whatever you're describing your business model as, simply memorialize it in the independent contract. It won't be binding necessarily on the court, but what you're attempting to do is to make yourself an unattractive target for a lawyer out there, and certainly an agreement memorializing between a possible plaintiff and between yourselves that this is your business is a roadblock that, or not a stumbling block that you would like them to have to drive over.
From the handout in the B point, and I don't know if it's still applicable or not, but around this area right there, it says B, the person performs work that is outside the usual course of the hiring entity's business.
Correct.
But then you have a side note. If the firm can be described as a referral agency matching reporters with willing clients, this would be satisfied. But such a description is hurt if you bill clients and maintain the relationship. Who is the you there? Is that
You
the
is-
CSR or the agency?
You is the agency. So it starts feeling a little bit more like you're in the business of court reporting if in fact and this is the person you're dealing with is not an arm's length transaction.
Mm-hmm.
If in fact you're doing the billing, you're doing the interaction, you're doing everything out with your client. Because if you think about a dating agency, right? I mean, once the date happens, the person who arranged for the date doesn't go with you on the date. So the referral agency tactic, I think, is a challenging one.
For anybody doing that, even go back to the modeling, even the modeling, and it's sort of eroded at that point for the same reasons.
Yeah. Because it doesn't feel like you're simply a matchmaking agency if, as I said, once the date's been set up, you're chaperoning the date the whole time. It starts to feel a little bit like something else.
Well, if you go off and get married, sure, I can see that. But these are one-time events. Ostensibly, a deposition could be a one-time event, right? We didn't go off and follow the attorneys around for life. Anyway, thinking out loud. So is the true or false, the already existing carve-out that exists in Unemployment Insurance Code 630, is that helpful for us, true or false?
It's extremely helpful, yeah. And I think it's helpful in sort of a variety of ways. If you are met with a demand letter from an attorney, knowing or being able to show this lawyer in a response that either that you write on your own or that your lawyer writes, that you're aware of this code section automatically diminishes at least some of the damages that might be available because you're exempt under the Unemployment Insurance Code.
Transcript of these proceedings, very helpful for us.
Is it? Yeah.
Really lucky that EDD person.
Yeah, if I recall, I got this from you.
Yeah, you got it from me, but I got it because of my blog, my EDD nightmare. Somebody,
Right.
a former accountant or somebody wrote in to me and suggested that we should take a look, and thank God. True or false? There currently is a class action lawsuit against Atkinson Baker right now.
I believe there is one. Yeah, I don't know the status of it.
True or false? Going forward, it is imperative that CSRs create a new legal entity, either an S Corp or LLC, rather than stay sole proprietors?
Well, I think that's true. I think yes, for two reasons. I think that first, it's just massively in the interests of individual reporters who, given the environment out there, a lot of them are making more money happily than they've ever made before. It just makes a whole lot of sense to incorporate. There's tax advantages. There's just any number of advantages. And I've been preaching that evangel for a whole lot of years for individual working reporters. But there's another reason too now, if you're a firm owner, and that sort of is a nice segue into AB5, because the business-to-business exemption that exists in AB5 would cover situations where an agency is contracting with another business, meaning a corporation, rather than individuals who happen to be a reporter. So if you have Ed Howard Incorporated, who is an individual reporter, and you hire Ed Howard Incorporated, Todd does, and your corporation does, then all of a sudden you are in the world of an existing exemption under AB5 because this is a business-to-business relationship. It's not a business to a natural just person or individual.
What was the question that my attorney, that you had for my attorney that day? Because a post on Facebook with some points that, and there were notes from my conversation with her right after AB5 passed last week, right? So I wrote this Facebook post and you saw some of that in preparation for your stuff today. But one of the sticklers that she had thought that you wanted clarification of, you remember what that piece was?
I do. I'm much more optimistic about the exemption applying in a business-to-business relationship than the counsel we were talking with. And in part, that's because after 20 some odd years of hanging around you guys, I know a little bit about how you do business. And a lot of the criteria of the business-to-business exemption in AB5 work quite nicely in a court reporting setting. And what she and I were focusing on is the question of who the customer is. And that's really what we were talking about. I think that she was concerned about was in a situation where a reporting firm, an agency, has the relationship with the law firm, right? Law firm calls agency contacts reporter then provides services for the deposition. The reporter in a lot of agency settings goes poof at times after that. A lot of times the agency handles the after the fact production. The agency handles the billing, a lot of that stuff all is agency related. So to the extent that the customer is the customer of the agency, the business to business exemption applies. And so that's what I'm more optimistic that then a lot of agencies operate in a way where they're servicing their customers rather than somebody else.
Does it complicate that food chain at all if the end client is actually, let's say, an insurance company paying the bill versus the law firm out of their own accounts paying the bill to the court reporter? Does that matter at all?
I don't think so.
Because for me, my agency, we invoice and most of our invoices go to insurance companies.
Yeah, so that makes it better.
That makes it better.
Sure.
Why?
Because the business, I mean, let's go directly to AB5. We can talk about it, right?
Sure.
So the idea here is in the language of this exemption in AB5, which is 2750.3E, in the lingo of this exemption, the business service provider is the individual reporter, is the reporter, and the contracting business is the agency. So if you take a look at what is E1B, capital B, one of the criteria is the business service provider, meaning the reporter, is providing services directly to the contracting business, meaning the agency, rather than the customer of the contracting business. So in the example of the insurance company, it's even clearer, right? That there is no sort of dotted line between the insurance company and the individual reporter, so long as the dotted lines are between the agency and its customer, meaning either the insurance company or the law firm. And so long as that's clear, then you're in the ballgame of being able to avail yourself of this exemption. And a lot of agencies operate in a very
similar fashion. For sure. Well, I can see why you're more optimistic then, too, from that understanding. Her advice was, the easiest thing. Well, no, not her advice. She said, option one, my attorney, that's what I'm referring to, is, hey, just make everybody an employee, call it a day. So my question, though, would be how would I convert 100 people to employee status overnight, and I can't?
Yeah, and more to the point, and I think the reason why we have a very, very good case for just a straight-up exemption is that over the course of so many years, what in part attracts so many people to this profession, especially women, is how flexible it is. It's precisely because they're not employees. They go into it in part because they're able to be independent contractors and set their
100%.
Yeah. So that could be a solution for some folk. I can easily see why it wouldn't be a solution for a whole lot of agencies or a whole lot of reporters who really might not want to be employees.
Very true. Hey, on January 2020, is a court reporting agency's safest method of proceeding, is it to, one, update the contracts according to, or adding class action waivers if they don't exist and arbitration clauses if they don't exist, to only give work to CSRs who are incorporated?
Or, if I may, one of the things that I suggest in the handout is in your contract to memorialize the fact that the reporter with whom you're doing business is an incorporated business.
Did you say is or is not?
Is.
Right.
So
that they certify that they are.
Yeah, that they're promising to you that they are. And in fact, what you would want to do is, again, to protect yourself to the maximum extent possible, ask for their incorporated name so that your agreement is not between, Ed, hey Ed, how you doing? It's between Howard Advocacy, between a corporation and between a company.
Those two things, the contract update, and then obviously exerting this similar level of no control so that you would pass both the ABC and the Borrello tests, and then hope for the best, or forward with confidence.
That's right. I really don't. The concept of all of this is to be an unattractive target for a lawyer who would have to invest his or her own resources as a plaintiff's counsel to be able to, or to want to sue you. Certainly, if you have a great paper trail, if your contract has in it that you can only that anybody with whom you do business, or the corporation with what you do business, can only sue you on an individual basis and can't do a class action, and can only do that in arbitration. So, and if you have memorialized that this is a business to business relationship, so that you arguably fall under the test that we just talked about, all of those things make you an unattractive target for anything other than sort of a small, nuisance value suit. And that's the game. In our society, you can never prevent yourself from being sued, right? Just anybody with
for anything at any time.
Yeah, with a computer and enough money to file a filing fee. All you can do is make yourself an unattractive target. And the constellation of all of those things, I think, make you a really unattractive target, because it's not just that you're unattractive in and of itself. It's like every plaintiff's lawyer operates like a venture capitalist, right? Because that's what they're doing. They're investing in
How big is it? How expensive will it be to climb that?
Versus how easy and profitable other opportunities might be. So you want to be an unattractive target so that someone does.
Let somebody else be the slowest in the herd.
It's exactly.
I hate to put it like that.
Yeah, that's right.
So
I'm plaintiff's lawyer too. It's okay.
It's so Darwinian or something. So lines.
It's exactly.
Did I miss any nuance?
I'll tell you one thing.
Okay.
You gotta talk to a lawyer, right? It's the advice that I'm giving you right now is no substitute for someone really looking under the hood of your individual business. It's an important thing to do anyway. And as I said, a whole lot of folk that I know and have watched over the years prior to the Dynamics decision coming down, they were probably violating even the Borrello test before. And so I think that there's an opportunity to avail yourself of the business-to-business exemption. Every individual reporter out there anyway should have the protection of a corporate form, should have the tax advantages and other advantages of a corporate form. And think of it as an opportunity to go in. It's an unpleasant chore when you got to do your spring cleaning, but this is a form of spring cleaning, but you do it with a lawyer who really knows your business, and you can.
Great advice. Did I skip catch-all number 2? Or is it kind of...
That's catch-all number 2,
that is
the one we were just talking
is the biggie. Catch-all number 1 was who is an employee, and that's the uniform.
Yeah. Catch-all number 1 is the referral. I'm not in this business. I'm a referral agency. Catch-all number 2 is I am in this business, but it's a business-to-business relationship. And notice something about it, and there's in the new handout, I actually drop a footnote about it. Those are a little bit mutually exclusive.
Yeah.
Those are two paths that kind of go down. Yeah.
Fork in the road.
Yeah, and that's part of the reason why it's so important that you consult a lawyer, because a lawyer is going to look at these two paths and then take a hard look at your business model and give you some sound advice about which is the best path for you.
And you got to pick one.
I think you do.
Have both feet on the,
Yeah, you really have to kind of pick one. If they point in different directions, right? So one of them is, I'm just a referral agency, so I'm not even in the same business as you are. And the other is, I'm in the same business, but it's a business-business relationship.
Okay.
It's a little funky.
Good question for your specific attorney, not you at this point, because you are an attorney, but you're not our attorney. You're not Todd's attorney. Or
I don't know
his attorney.
I don't know enough about your business.
Yeah, clearly. Yeah. Hey, why do you think that some industries' lobbying efforts prevail while others didn't really stick this time?
There's no way to know. I mean, if you look at the list of professions that got in,
it's like
it's a
smorgasbord. Right?
Yeah. So I honestly don't. I honestly don't.
On a scale of 1 to 10, how big of a priority do you think that organizations like DRA, Deposition Reporters Association, or CCRA, or others should make a specific carve-out exemption a priority in 2020?
I don't. I take orders.
Okay. You don't prescribe.
So I don't really know. I mean, it's with legislation, there's, it's never a univariable situation, because it's always what else is going on at the time.
Yeah.
So, and, remember, we're not in control of what other bills other people put in. So you could, expect that you're going to make this or something else your number one priority, and somebody else drops a bill which you want to try and kill or change massively. So you never really know, but that's not up to me. It's up to the board.
I'm hoping that it becomes a high priority so that we can just end this all once and for all of us, and incorporating industry very selfishly. That's all I care about.
That would be good. And, one of the things that causes me optimism about it isn't just that many individual corporators genuinely don't want to be employees, but the other is that unemployment insurance code section, which, there you've got the precedent of an explicit exemption in the labor code for your profession. So,
Ed Howard, I really appreciate your time.
Pleasure, Todd.
I want to come back and I'll go up to your neck of the woods, because you're in Northern California,
Sacramento. And
if you would indulge me, sit down and hear the other sides of your story, and from growing up and going to school, and then because I think you're a really, really inspiring guy, so respected. And today's was just a quick little thing about this whole AB5 stuff, but man, you're the real story. So
okay, well, that would be I would be boring. I mean, I hate talking about myself, so I hold you in such high regard that I would be willing to do that, but expect a lot.
I'll come up there and edit those out.
Good.
Ed Howard, thank you so much.